Hi, I'm attorney Ben Schwartz. Today's video is something that is a little bit different from our typical videos. I'm an attorney in Delaware. I also handle cases in Maryland. Our office handles personal injury cases in Pennsylvania and New Jersey too. And it's not uncommon for me to have other attorneys inside my firm and attorneys outside my firm ask me about how to evaluate personal injury cases, prospective claims, prospective personal injury cases where their clients have contacted them and want to pursue a claim. And so I find that I sort of repeat myself over and over. I thought to myself, boy, if I did a video and sort of put together my way of thinking, put on video my way of thinking about how to evaluate a case, then that would be something that might be helpful to other attorneys or to people who are trying to evaluate whether there's a claim that is viable, a claim that is a personal injury claim that should be brought. So today's video is going to be 10 best questions for personal injury lawyers to ask in evaluating sidewalk slip and fall accidents. Number one is there a defect in the design, construction, or maintenance of the sidewalk? In order to have a liability case, you have to have liability. And so what you're looking for is some dangerous condition, some defect in the walkway surface. And when you're talking about sidewalk personal injury cases, the common causes are things like slip and falls on ice or snow that was not timely and properly removed from the walkway surface. You see cases involving deterioration of the walkway surface in sidewalk cases. You see sidewalks that were not properly constructed. Maybe they're not level, or they're constructed with large spaces between the segments rather than thin expansion joints. You see different types of defects, but the first thing that you need is some sort of defective condition or dangerous condition in order to have liability in the first place. The second question is, can the client articulate the mechanism of injury so that you can determine, as the attorney, you can determine whether the defect in the walkway surface proximately caused the accident and the injuries that resulted. And in my law practice, one of the things that I find a little bit surprising or a little bit disconcerting is the number of clients or potential clients that contact us about a slip and fall case or a trip and fall case, oftentimes on sidewalks. And we ask them, how did the accident happen? And they say, I don't know, I just know that I fell. The problem with that is that if the client cannot credibly articulate the mechanism of injury, they can't articulate for you how they fell and why the defect or the dangerous condition caused them to fall, then you can't assist them to make a claim. Because what you need is to have a defective or dangerous condition that results, that proximately causes the injury. The third question for personal injury lawyers who are evaluating a sidewalk slip and fall accident is there comparative fault or contributory negligence? And if there is it going to bar the claim? So different states have different laws when it comes to the plaintiff's own negligence. I said when we started the video, I'm admitted to practice in Delaware and Pennsylvania. In Delaware, we have comparative fault. So as long as the plaintiff is essentially equal to or less negligent than the tortfeasor, than the at-fault party, the plaintiff can still maintain a lawsuit claim. The plaintiff can still recover. It's just that their award of damages will be reduced by their percentage of negligence. In Maryland is a straight contributory negligence state, and so in Maryland the law is totally different. If the plaintiff was negligent in a manner causing or contributing to their own injuries, then they're going to potentially be barred from recovering. The fourth question in evaluating a sidewalk slip and fall case is, who is responsible for the ownership, maintenance, and use of the sidewalk? Is this sidewalk on private property? If so, get the deed in order to see the meets and bounds description and make sure that you're able to identify the owner. Is the sidewalk the type of sidewalk that runs parallel to a roadway? If so, it may be municipal property. And if that is the case, you need to find out if the town or the municipal government has a charter provision or a code provision that requires you to put them on notice within a short period of time. Throughout the United States of America, I would say that the vast majority of municipal governments have a town charter. The town charter provision has something in it that says within a short period of time, the plaintiff or the potential plaintiff has to notify the municipality in some particular format that they have sustained the injury as a result of an accident. Also, if this is a municipal walkway surface, can you get records from the municipality? You know, say go on the town's website and search through their meeting minutes and see if you can find some documentation that the town was maintaining the walkway surface, that the town was taking action to repair sidewalks in that area. The fifth question for personal injury lawyers who are evaluating sidewalk slip and fall accidents is this: if the municipality is responsible for the sidewalk, does the municipality have immunity under a Municipal Tort Claims Act? And if you think they do, is there an exception to that municipal immunity for whatever type of sidewalk this is? So in Delaware, we have a County and Municipal Tort Claims Act that gives municipal governments essentially a very broad immunity in negligence personal injury lawsuits arising from use of municipal sidewalks. There are exceptions to that. You know, there are exceptions to the municipal immunity for, you know, public buildings and automobiles and things of, you know, operation of automobiles, things of that nature. And so, at least in Delaware, and I suspect in other states too, it's very important to take a look at the statute, the municipal immunity statute, as well as the cases interpreting that statute, to try and figure out if it's likely or unlikely that there is some immunity provision that might give the sidewalk owner, if it's a town or a government, give the sidewalk owner a free pass in your negligence lawsuit. 6. We sort of touched on this already, but if the municipality, if a town or a township or some other government entity is responsible, is there a charter provision requiring a foreshortened notice requirement? So, you know, I looked at a slip and fall case that happened in a town earlier this week, and in the town charter, there's a requirement that notice be provided to the town clerk within 1 year from the date of the accident. And that's in a lot of town charters. That's something that is probably not unique to Delaware. So if you are an attorney and you're handling a slip and fall or trip and fall case that happened on municipal property or town property, then you should be getting into the town charter or the municipal government's charter to see if there's a notice provision and make sure you follow it to a T. Otherwise, you may be waiving your client's claim. Number 7, the 7th question that I would ask in a personal injury case involving a sidewalk slip and fall or trip and fall injury is, how long ago was the defective sidewalk created? How long ago was it constructed, or how long ago was the repair made? And the reason I ask that question is because there may be a case against the person who designed that sidewalk. There may be a case against the construction company that constructed or repaired that sidewalk. But many areas have what's called a statute of repose. So in Delaware, for example, we have a 6-year statute of repose, which means that if 6 years goes by after the construction is done and there's been no injuries, and then your client has their injury, the time period may be too long to go back and file a lawsuit against the construction company or the engineer or the architect who designed that sidewalk surface. And that is something that's separate from the statute of limitations. It's called a statute of repose, R-E-P-O-S-E. Question number 8 is, if you've got a client who has a sidewalk personal injury, sidewalk slip and fall case, question number 8 is there MedPay coverage available through the property owner or through whoever is maintaining the premises? MedPay insurance is no-fault insurance. Under a lot of commercial insurance policies, stores and businesses and other entities will maintain MedPay coverage. A lot of times it might not be more than, say, $5,000, but if you can access that coverage and it helps pay your client's medical expenses, that can really help out your client, especially if they, if they're out of work due to their injury, they have health insurance, but the health insurance requires them to pay a deductible or to pay copays. They may find that very burdensome when they don't have money coming in. And so if you can find MedPay coverage, then that can help them get medical treatment without having to pay a copay or deductible, and that can be a huge thing for a claimant or a plaintiff who's been injured in a sidewalk slip and fall accident. Question number 9 is there PIP available? So if you're an attorney and you're handling personal injury cases, you'll know that PIP stands for Personal Injury Protection Insurance, and that is insurance on an automobile that pays for medical expenses and lost wages. Oftentimes, people have slip and fall or trip and fall cases on a sidewalk after alighting from a motor vehicle. And so if you can contact the insurance company for the motor vehicle and make a PIP claim, you may be able to get their medicals and lost wages covered under PIP. In some states, like in Delaware, there will be a law that says that in an action, in a lawsuit against the tortfeasor, the plaintiff cannot plead or prove medical expenses that were payable under PIP. So if you're in a state where there's a PIP scheme, in auto accident cases, where there's a PIP scheme that requires the PIP to pay medicals and then subrogate against the at-fault party's insurance company, you may find that you cannot collect in a third-party claim, in a negligence case against a negligent actor, you may not be able to collect amounts that were paid or payable under PIP. So that sounds kind of complicated, but to try and make it a little bit more straightforward, in my state, in Delaware, if I'm injured in an accident, my PIP pays. If I sue the at-fault driver, I sue the at-fault party, I'm not pleading stuff, I'm not pleading medical expenses, I'm not pleading lost wages that were paid under PIP. In Delaware, it doesn't matter if they were paid under PIP or if they could have been paid under PIP, they're not pleadable. And so what you run into, if you handle a significant number of slip and fall cases, what you'll run into is situations where the accident, the slip and fall accident, involved an automobile. PIP could have paid. You didn't think to make a PIP claim to get PIP to pay it. And when you file your lawsuit against the premises owner, you get to the eve of trial and they file a motion in limine to exclude the first, $15,000 worth of medicals from being introduced into evidence at your trial in the slip and fall case. under the theory that, hey, if they were PIP eligible, if they could have been paid by PIP, then you can't introduce them into evidence in the slip and fall case. And so the bottom line is, if you're an attorney and you've got a slip and fall case occurring on or near a sidewalk, and it also involves someone who just got out of a car, and many times it does, what you need to do is you need to contact the auto insurer, put them on notice of the claim, make a PIP claim, make application for PIP benefits, and either get the medicals and lost wages covered or get a denial letter and stick it in your file, so that when you get to the eve of trial in your slip and fall case, you won't find that your medical bills are excluded from evidence. Number 10. Question number 10 for attorneys who are evaluating slip and fall personal injury cases that occur on sidewalk or walkway surfaces is this an accident that occurred while my client, while the plaintiff or claimant was on the job? Because if so, workers' comp would provide coverage for medical bills and lost wages and other items of damage. So there you have it. There's my 10 best questions for personal injury lawyers to ask when they're evaluating slip and fall cases that occur on sidewalks. I hope you found this to be informative. I certainly see a lot of sidewalk slip and fall personal injury cases. I see all kinds of slip and fall personal injury cases. If you're an attorney and you have a question about evaluating a personal injury case that involves a slip and fall, feel free to send me an email or reach out to us through Facebook. My email address is ben.schwartz@schwartzandschwartz.com, and our Facebook address is facebook.com/schwartzandschwartz.